How are you?
I'm good, sir.
When is your interview?
25th.
25th.
Yes, sir.
Okay. So let's keep it in a simple conversational format.
Sure,
Whatever
sir.
you want to ask, you let me know. And rest, whatever little experience I have, I am definitely going to share that with you.
Okay,
All
sure.
right. So where did you do your law from?
I did my BLLB from Rajiv Gandhi National University of Law, Patiala, Punjab.
All right. And this is your first attempt at DJS?
No, sir. This is my third attempt, but this is my first attempt for interview.
Okay, first interview.
Yes, sir.
All right. So how's the preparation? I hope everything is fine.
Yes, sir.
Okay. So first you let me know. You want to ask anything particular?
So, sir, I have also done my master's and I'm currently working as an assistant professor of law. So, I was hoping that they will ask me questions majorly from my dissertation or the subjects that I'm teaching. So, my dissertation was on juvenile justice act, juvenile justice system, and the
Okay.
subjects that I'm teaching it also includes JJ Act and POXO Act
Correct.
and victimology and penology. I am also teaching fundamentals of jurisprudence, but I'm not very thorough with the subject. So I am planning to skip that part that I'm teaching fundamentals of jurisprudence. So what I was thinking that what I was expecting that they will ask me majorly questions from these subjects. But my civil law, जैसे arbitration and commercial courts act and TPA, तो ये इतना मेरा strong नहीं है. तो मैंने पढ़ लिया है. It's not that I have zero knowledge about it, but वही मैं सोच रही थी कि should I focus on those subjects, and also my constitution is also not very strong. I have read constitutional provisions regarding children, however, लेकिन पूरा constitution थोड़ा सा मेरा it's not that strong. तो मुझे वैसे as such I don't have any major problem because they are going to ask me random questions. तो I'm not taking that much of stress कि क्या पूछेंगे क्या नहीं पूछेंगे. They will ask me whatever comes into their mind. तो वही मैं सोच रही थी कि or like is there anything that I need to focus specifically on?
शिवांगी देखिए, एक चीज आप ये मान के चलिए कि आपके केस में ये प्रिजम्पशन है कि सिंस यू हैव रीच्ड द इंटरव्यू स्टेज यू नो थिंग्स, right? So the sole purpose of interview is never to check your knowledge in the subject. Okay.
Yes, sir.
Because that you've already proved by clearing prelims with your aptitude and mains by your aptitude for writing, analyzing, and writing or answering the question, right? That's all there. So what we are looking for is a candidate who is good enough for the post of judge. So we'll be judging that candidate on the basis of his or her personality, right? His presence of mind, okay,
Yes.
and response to the questions. You take
Yes.
it from me, even though let's suppose somebody asks you 5 random questions, you're not able to answer one, that is not a judgment on you, because everyone knows humanly it's not possible to know each and everything, right? So let's suppose I ask you what is your favorite subject, and you tell me, let's suppose Hindu law is your favorite subject. Can you know everything on Hindu law? No.
No, sir.
Your
Yes.
domain is also limited. No, you'll read your barracks, you'll read your notes. You cannot answer each and everything.
Yes, sir.
That okay, what was the precursor of Mitakshara School of Law? I mean, it can go back wherever you want, right? So just don't worry about it, as you rightly said. Unless somebody asks you, look, so I'll go just step by step. See, if you're working as assistant professor, so part of, I would say majority part of interview shifts to that also, right? So if I'm looking at your profile, I get to know that you are working as assistant professor. First, I want to know how good you are.
Sir, I've recently joined it. It's been only 3 to 4 months.
Okay. See, let's suppose you are bombarded with so many analytical questions, they're not comfortable with all of the question. At some point, you can say, sir, I am in the process. I am also learning. I read this act just for the sake of examination. Since I'm teaching it, I'm reading it in great length and breadth. राइट। एंड वही आप 4 महीने से पढ़ा रहे हो तो 4 महीने में पीएचडी तो नहीं हो जाएगी जेजे एक्ट की, वो पैनल को भी पता है। बट वो होता क्या है ना, वो थोड़ा एक इंटिमिडेटिंग वे में क्वेश्चन जरूर पूछे जाते हैं। पैनल की भी तो कोई रिस्पॉन्सिबिलिटी है ना कि इफ यू नो विल बी आस्किंग टू सिंपल क्वेश्चंस, तो आपको भी ये मजा नहीं आएगा कि फिर ये डीजेएस का इंटरव्यू है, करेक्ट। तो वो थोड़ा रहता है, बट आवर लेसन इज वी शुड बी थॉरो विद द सब्जेक्ट एंड वी शुड बी एबल टू गिव आवर 100%। अब आप सिंपल देखिए, आपके केस में आपकी जो डिसर्टेशन है वो जेजे एक्ट के बारे में है, ठीक है। सो लेट अस सी व्हाट आर द बेसिक क्वेश्चंस दैट आर एक्सपेक्टेड, राइट। जेजे एक्ट का सबसे ज्यादा इन द लाइमलाइट वाज निर्भया केस, करेक्ट। आफ्टर निर्भया केस वी हैड एन अमेंडमेंट। अच्छा, व्हाट एग्जैक्टली वाज द अमेंडमेंट, है ना। वो 16 to 18 वाला क्या हुआ क्या नहीं। नॉर्मली ऑल्सो आई आस्क्ड दिस क्वेश्चन मेनी टाइम्स दैट इवन आफ्टर दिस एनसीआरबी डेटा शोज दैट क्राइम अगेंस्ट women or sexual offenses have not reduced. So what is the remedy, right? So these kind of opinion based questions will definitely be there that you can easily answer, not a problem. It's like just one word of advice, like obviously you can have your own answer. One answer could be, let's say, that you understand that NCRB data says that the crimes are still rising. See, what is the root cause and what is the solution of this entire thing? The problem is there are no convictions happening. Trials are taking a lot of time, right? And why trials are taking a lot of time, it depends. Everyone is a party to it, be it defense lawyer, be it public prosecutor, be it judge also, in a way. I mean, you cannot say much against the judge, obviously, because see, everyone has a certain responsibility, and if one is hell-bent on discharging his or her role, then only we can secure an early conviction, if at all that person needs to be convicted. So if there will be early convictions, our law will be more effective. Like if we see in the small countries like Dubai, why people are scared of law there? Because conviction is very early. In a year's time, he may hang somebody to death as per the law, and they are able to complete their convictions also. So if convictions would be timely, right, people will be more scared about law, and eventually and logically also crime should reduce. But now what happens if even for the point of view of accused also, trial is taking too long. Sometimes he'll be able to secure bail or he'll not able to secure. So since if you have that time frame, no, so you will be little in a way relaxed, right? So if the time frame is reduced, right, so trials can be conducted timely. But it's a collaborative and joint effort on the part of everyone: judge, defense lawyer, public prosecutor, client also. Because when you see the witness examination, sometimes witnesses are not available, and the witness is available for chief, witness is not available for cross. How to go about it, right? So everything. Then with respect to JJ Act, okay, we made this amendment, right? So what exactly changed on ground? And what is your personal opinion? Do you think adults who are the age of 16 to 18 should be tried for heinous offenses?
Sir, as per my opinion, they should be tried. But the objective of the JJ Act was not to punish the juveniles. The objective is to rehabilitate and reintegrate them into the society.
Society, correct. So even in the Nirbhay case also, there was one person who was under this age. There was a who cry on this. A question can be, are you going to, bow down to the public pressure also? Like, for example, this, your next question in the series would be uh, about death penalty.
Okay, sir.
Right? So, do you favor death penalty? Okay. Or are you against it? Correct. And if there's a question about death penalty, you'll be asked about what is your opinion about the decision in RG Kar case.
Yes, sir.
Okay.
Yes, sir.
So, in my experience, I have also asked these questions, even in the many other interviews also. So many candidates have replied, "Sir, if I would have been the judge." So the question was, if you would have been the judge, what decision would you have given? That accused has been given life imprisonment, right? So the question was asked, if you would have been a judge, what decision would you have given? So they said, "Sir, we would have given death penalty since the crime was so horrific."
But sir, I would say that the judgment should be based on the facts and circumstances of the case. If the prosecution is able to prove that, if the prosecution is able to prove the case beyond reasonable doubt, and only in exceptional cases, the rarest of rare case, if the case falls under that category, then only the death penalty can be given. And it has also been mentioned by the Honorable High Court of Kolkata that the case does not fulfill the ingredients of the rarest of rare doctrine.
Not High Court. You said observed by Honorable High Court.
Kolkata High Court, yes, sir.
No. Calcutta High Court has not given that decision. Sessions.
Sessions. Oh, yes,
Sessions
it
Court.
has.
Yeah.
Yes,
Sessions
sir.
Court. Sessions Court. Now it'll go in appeal. Yeah, very true also. Because see, if somebody is asking me this question, okay, if I am able to answer this question, it presumes that I have read the entire judgment. Have we read the entire judgment? No.
I have read the judgment, but I also think that the chain of circumstance, because the whole case is based on circumstantial evidence, and I feel, in my personal opinion, that the chain of circumstances have not been duly proved by the prosecution.
Yeah, so
So,
I'm saying one view is you are able to comment on the judgment only if you have read the entire judgment, right?
yes, sir.
Second thing is because you say that you would have given a death penalty. My next question would be, you tell me what were the mitigating circumstances in this case on the base. See, if a death penalty needs to be given, we need to see the balance between aggravating circumstances and mitigating circumstances. So if you are giving death penalty means aggravating circumstances have more weightage than the mitigating circumstances, correct? So
Yes.
next question that I will ask you is, what are the mitigating circumstances in this case? So whatever can be, let's suppose it was a first time offense, he was intoxicated, whatever it was.
Yes.
So I'm saying, if you are entering into that domain that you are going to answer this, be sure that we are clear about these basic things, right? At least what were the aggravating circumstances in this case. Eventually, obviously, court would have considered that the case didn't fall under rarest of rare category. That is why they've not given the death penalty. You can have you can favor the judgment also, you can criticize the judgment, absolutely no problem. But as a candidate for judiciary, your answer should reflect that you have in-depth knowledge about the things, right? I am not saying you should be reading, entire judgment word to word. So let's suppose if you open the judgment and you see the conclusion part, you'll be able to figure out what exactly it is. Because, I mean, considering your profile, this question is expected. So I will only say, just because if you quote these particular instances in your answer, it will make your answer more effective.
Okay, sir.
Not that any standard answer. Since, see, you are a smart lawyer, they also know this, you can easily answer, right? Aggravating, this rarest of rare, these are very basic things. So if you would have read that, this will also give a good meaning to your answer, that okay, whatever you said is correct only. That what you said, that circumstantial evidence, there is law, no, we need to be very careful if conviction is to be based on the circumstantial evidence, right? What all was there. Just I would advise, just take a overall view of the judgment or the
Okay.
conclusion part. You don't need to go into evidence and all and everything. Just take an overall view, right? This will give you a good and another thing is that victimology or criminology, obviously death penalty would be covered in that. So if we see the new laws, BNSS, there's you would say, see, IPC has been changed into BNS. This is also the question that it was a penal code. By now, the penal word has been replaced with nyay, right?
Yes, sir. Yes.
So why instead of penal? Because it's a simple penal statute defining all substantive offenses, right? So why have you called it nyay? So there's an element of justice to it. Maybe they have introduced that community sentencing. This community sentencing part is also very important from your topic also, right? And are there any other provisions with respect to, if we talk about victims or compensation, have they added anything new? And in place of criminal procedure code, which was it's still a procedural law, why have they named it as a Nagrik Suraksha? What new things have been added about it, right? this
Yeah.
also you can take care of that. And standard question is why the new laws have been brought by the government. So obviously, standard argument that is given is they were colonial in nature. Okay,
Mm.
so just be you have to be little careful about it, because I would expect some in the entire interview, somewhere deep down I would also expect some out of the box thing, like not very standard thing to say. See, everyone knows, they say, okay, let's talk about this colonial argument, right? Our CRPC is what year? 1973, correct? Which was the previous CRPC? 1894. So
Mhm.
it means we have had our own CRPC in 1973. Whatever
Mhm.
colonial element would have been there in 1973 were pretty much Indian, right? So
Yes.
whatever colonial element would have been, that would have been gone, right? Other thing is, if we talk about 1947 as a base year, after that we had a lot of amendments in IPC and Evidence Act also. So there were many provisions which Britain government was being referred for a particular thing. So with series of amendments, whatever colonial was there in those two laws also, that was also done through series of amendments.
Yes,
Then what was the need of doing this entire exercise? That you have tinkered with the entire jurisprudence. So what is the answer to that? We should be clear in our mind, right?
yes.
Not simply that it was colonial. If you ask this colonial thing, say, so these can be the follow-up questions. I'm just giving you instances. Okay.
Yes, sir.
Also keep in mind some newly added provisions. Okay, like
Yes.
we discussed, why it's called Nyaya Sanhita, Nagarik Suraksha, that community sentencing. What about
Mhm.
victims and all? And
Mhm.
in certain things, they have added timelines,
Mhm.
that within this much timeline this should be completed. And don't stress about it. You should be knowing each and everything. Just basic things we can try.
Yes, sir. Yes, sure.
Rest, simply say, sir, I'm not able to recall, because I
Okay.
don't think so. If you know it, you certainly can't guess it, right? So it's
Mhm.
better. Honesty is best liked by the panel also. Sometimes if
Yes.
you try to, and they'll be knowing whether you understand it or not. Another question can be regarding that police custody thing.
Mhm. Yes, sir.
There's a
Default.
default bail. So it's being said that now initially police remand could have been only of 15 days as per 167(2). So now they have changed the proviso part, which allows them to have police custody for 60 to 90 days, virtually converting it into a police state. What about it? Just read a good article about it. You'll have a fair idea. Regarding that timeline part also, they've introduced timeline. Okay, that let's suppose judgment is if arguments are heard on a particular day, the judge is bound to give judgment within 45 days or something. There's one timeline. So the question can be, do you really think it's practicable? Is it a
Mhm.
practical thing? Do we have the infrastructure about each and everything that trial can be completed within the deadline? Right? It's not that we only have to be theoretical in our answers. We are also looking for a practical aspect to it. Okay, theoretically you know many things. If I'll ask you a particular problem, you can give me 10 solutions because you have read the law, what law says, right?
कि प्रैक्टिकल
हाँ
आंसर्स
हाँ
भी होने चाहिए।
हाँ, तो थोड़ा थोड़ा मैं ये भी चाहूंगा कैंडिडेट से कि आप थोड़ी ना एक प्रैक्टिकल अप्रोच भी दो। मैं आपको बोलूं कि इतना टाइम लग रहा है तो इसका सोल्यूशन क्या, आप बोलो कि अब तो नए लॉ में ना डेडलाइन आ गई है, दैट इज द सोल्यूशन फॉर ऑल। नो, यू ऑल्सो नो इट, आई ऑल्सो नो इट, राइट? तो थोड़ा एक प्रैक्टिकल एस्पेक्ट होना चाहिए आंसर्स में। बिल्कुल हमें थ्योरेटिकल नहीं जाना
यस सर,
है
श्योर
ना?
सर।
तो वो चीज़ एक बहुत ज़रूरी है। अब जैसे जूरिस्प्रूडेंस वगैरह है, अब देखो, वो ये है कि
सर आई विल नॉट मेंशन दिस ज्यूरिस्प्रूडेंस पार्ट।
एग्जैक्टली,
हाँ,
जस्ट डोंट मेंशन इट। अगर
हाँ,
कहीं
हाँ।
उनको कोई क्वेश्चन आता भी है, लेट्स सपोज आपने अगर जूरिस्प्रूडेंस मेरे सामने मेंशन किया होता, तो मैं अब पूछने को तो कोई लिमिट नहीं है। आई वुड हैव सिंपली आस्क्ड, मेरे दिमाग में जो पहला क्वेश्चन आता मैं पूछता, व्हाट डू यू मीन बाय ग्रैंड नॉर्म बाय केल्सन? केल्सन ने क्या बोला? बट अब ऐसे तो पता नहीं कितने हैं, नेचुरल थिंकर भी हैं, पॉजिटिविस्ट भी हैं, है ना? तो वो तो उस चीज की तो कोई लिमिट नहीं है। जस्ट से इफ यू डोंट नो, यू डोंट नो, क्योंकि इसमें जूरिस्ट में भी वैसे गेस नहीं कर सकते। जो आपको पता होगा वो पता होगा। आर्बिट्रेशन कंसिलिएशन के रिगार्डिंग ये है कि ऑब्वियसली अभी ना एक तो recent में you would have seen, see, first thing is it derives power from section 89 CPC, right? Alternate dispute resolution. So the usual question can be, do you think arbitration is effective, has proved itself to be an effective remedy, right? Because acha, see, so what are the challenges in arbitration now? So we have a separate system, right, where an award is passed, then eventually what happens, award is challenged under section 34, then it appeal goes in section 37, then 136, but you still can say that arbitration is still effective for the simple reason that generally there is a deadline within which you have to complete the arbitration, right? And after that, only with the prior permission, that the mandate can be extended. If we read section 29 capital A, you must have read about it, right? So there is still fixed timeline to it. You cannot stretch it. I mean, much in uh, that you cannot stretch it for innumerable times. Okay. Then after that, so the next question can be, again, it will go before court. So it means the same thing. No, it doesn't mean the same thing for the simple reason. Under section 34, there are very, very, very limited grounds. Okay.
Yes, sir.
And interpretation is also to the fact that you shouldn't be easily interfering, right? Then the burden is even more in case of 37. It's very difficult to, interfere in section 37 jurisdiction, and eventually 136. So that is still there. So recently, Constitution Bench was hearing a matter with respect to section 34. So though the judgment has been reserved, and I don't think so it is going to be pronounced till the time you're there. If it is pronounced, you have to go through it once. But they can simply ask what was the issue about. So the issue basically was, you must be knowing, the issue was basically section 34. Does section 34 has power to modify the award, right?
Yes, sir.
So because now what happens now, if it's set aside again, you'll have to go and do the entire arbitration, which is a very costly affair, right?
Yes.
So there should, acha. Now, if we say that court can modify the award, that means court is stepping into the shoes of arbitration. So it originally, for which we brought arbitration, now we are again going back. If court is to step in, so what needs to be done? In what cases, what needs to be done? That's a little tricky question. Okay. And I would advise just read one article from Live Law where there are arguments, read from both sides.
Okay, sir.
Solicitor General argued or what Mr. Datar argued. You'll have the opinion of both the guys, right? Both sides. So Mr. Datar was arguing there's a power of modification, and Mr. Mehta was arguing no, there is no power of modification. It is what it is. We'll be doing injustice to the language of Section 34 if we, tinker with its meaning and all. That also you can go through. And I mean, you yourself don't mention about whatever subjects you told, TPA or constitution and all. Whatever they ask, they can ask. Rest there can be 2-3 situation-based questions also. That let's suppose you are posted as a judge, right? Let's suppose a senior judge calls you and tell you to decide a matter in a particular manner, which is not in a way that you want to decide the matter. What are you going to do about it? Right? These kind of situation based questions. And let's suppose on one side you have many lawyers saying that matter needs to be heard today, other side saying they cannot argue the matter today. Right? What needs to be done? What will you do? Then so some recent, you might be asked about your take on the recent controversies. Let's suppose this Ranveer Allahabadi episode.
Okay.
So in that also legal thing is involved, right? So, what do you think about it? If I ask you about this episode.
Sir, I don't think so that it is. See, I don't think so. मेरा answer वहाँ पे चलेगा because मुझे personally I don't think so it's that big of a issue that has been created, and even I am not totally in agreement with the remarks that has been made by the Supreme Court because an order about anything should not contain the personal opinions of a judge. The order should only be based on the facts and circumstances. It should not be based on the personal opinions of a court. So I do not. See, I think it falls under the category of obscenity and immorality, but it should be taken it should be taken like a normal case. It should not be hyped that much. जितना अभी हो गया है, तो this is my personal opinion, but I think this answer will not be. I should not like say this answer क्योंकि मेरी personal opinion मुझे लग रहा है थोड़ा.
I mean, certainly, see, everyone has a personal opinion about the case. You also, I also, right? See, what is the answer that needs to be said in the interview? Obviously, I mean, it's not something that you can answer total contradictory to your thought process, right? One cannot
Yes.
do that, and one should not do it. There's no harm in that, if you have a particular view. It's just that, see, how you can frame your answer. You can simply say there were certain comments which are allegedly obscene in nature. Even if we talk about freedom of expression, there are reasonable restrictions in the
Yes.
constitution also, right? Can it be termed as obscene? But this, media trial, and we have to think from the both ways, right? There's a particular channel, and for that you had a subscription, right?
Yes, sir. Yes,
You need to
exactly.
pay for it, and you do it. If somebody is saying if you want to watch this content, you should watch, otherwise you don't watch, right? Was there a problem with that? There was a problem because there was no disclaimer. Usually it's coupled with the warning and all. There was no warning with respect to that. And what happened was people made small snippets of that, put it on Insta and YouTube Shorts. That is why it got viral, right? So and the standard thing is more than taking down the content or whatever, regulation is the solution. You can regulate it. There's no problem with that. Maybe with the disclaimer, maybe with the warning. Same as with pornography, right?
Yes.
I mean, in a way. So, and there's other content also on Netflix, right? And I mean, you're a little bit here and there, you can vary your view, whatever you feel, right? And the other thing is, why has he approached the Supreme Court? Under what proceeding has he come to Supreme Court? Are you aware about that?
I think he has taken anticipatory bail. I'm not sure, sir.
No, actually, what happened? So there were FIRs filed against him in various states,
Yes,
right?
yes.
Right. Let's suppose an FIR is filed against 3 states, right? So will I be able to defend myself in those 3 states if it's
No.
pertaining to same offense? No. So it will affect my right to be defended, right? Which is my constitutional right. So what I'll do is I would want it. I should be tried under one FIR,
Yes, sir.
particular FIR, right? If which is in Mumbai, which is also convenient to me if I'm staying there. So now there are 2, 3 states involved. I will have to file a criminal writ petition under Article 32.
Okay, sir.
Yeah. So Article 32. So he has approached under writ petition under Article 32. More than anything, we should be concerned about the how you can be simply asked under what provision or what proceeding has he come. So Article 32 has come so that other FIR should be stayed and no more FIR be registered against him. Otherwise, if an FIR is registered, you'll have to go to that police station in that particular state in that particular place. That's affect his right? So that is why Supreme Court stayed the FIR and put on conditions that you have to go by this. Whether you agree with those conditions or not, that's a separate thing. All right. And overall, you just revise your law subjects, right?
Okay, sir.
It's not like mains we have to, with tension or stress, you have to revise or do those revisions. It's not that. Just go easy. But keep revising. Because even if you don't know any particular provision, you should have an idea about it, right?
Yes, sir.
Let's suppose somebody asks you, what do you mean by onerous gift in the TPA? What is the
Yes, sir.
concept of marshalling? Just a general thing you can easily answer. But still, I would say we still have how many days you have? 5 days.
5 days.
5 days.
4 days.
4 days. So nothing
Yes.
much to stretch about it. I mean, you already know things, and there's not a problem. Just keep on revising 2, 3 subjects which you think, or you can pick a particular subject which you can revise in little detail if you want to say a particular subject. Let's suppose somebody asks you there. which is one subject that you want us to ask questions from. You cannot say no, right? You'll have to say a certain subject. Just keep that thing in mind, whatever you want to say, and say that. Plus, current, we have already discussed just 2, 3 instances. Uh, Keep reading live law or bar and bench or newspaper. What are the current things involved, right? And opinion-based questions also, I think you'll do good. It shouldn't be a problem for you. So, uh, and other thing that you need to focus on is if somebody asks you about what are your hobbies and all, what do you like to do and all. So 1 or 2 questions can be from that also. And other thing can be, why didn't you practice as a lawyer? Why judiciary? What should be
So
our
I really have no answer to this question that why I want to join judiciary, because I have been preparing for so long. That is why, and I always wanted to be a judicial officer. It's as simple as that. I do not have that moral answer to it, that I want to serve the society or such other things. I just wanted to be a judicial officer, and I've been preparing for it for past 3 to 4 years, more than that.
Mhm.
So
See, you're right also there. I mean, so it seems very artificial also. You'll have to, if you'll have to create an answer. No, I completely understand. You want to become a judge, you want to become a judge, right? So see, but if at all a question is asked, why not as a lawyer? So you can say many things. First thing you can say is, I'm just giving you instances. That's my temperament is that I'm more suited to become a judge, right? Maybe I'm not very of the confrontational type. I'm more a justice oriented. I like seeing right and wrong among the things, right? It's always so. I think I'll better discharge my role as a judge. So in my legal knowledge would be put to effective use when I become a judge. And you can also say even I mean, there's no wrong in saying that power and status of a judge also appeal to you. Definitely. I mean, there's no, I mean, it shouldn't be the only thing that,
yes,
okay, judge has a power or a status. That can be one of the reasons. Uh, Plus, you're from Delhi.
yes, sir.
Okay, you're from Delhi only. And plus, you can have a, balanced family life also,
Yes, sir.
right? Had it been you might be asked, are you appearing for any other state judiciary? Are you?
No, sir, I'm not.
Okay, you're only targeting Delhi.
Yes, sir.
Okay, then it's fine. Uh, this you can say, and
I think they can also ask me that since I've started working as a assistant professor, so why don't I stick to that job only? Like, why do I have to come into judiciary?
yeah, see, one thing is, if you have to say that you want to become a judge, you need not say that you don't like being a professor, right?
Okay.
If you like
Yes.
something, that should never be at the cost of something else.
Yes, sir. Yes, sir.
Okay. There can be many reasons. You said you have been preparing for long. Okay. You have read about it. Now you don't need to devote as much as time. You wanted to do something which will even give you more exposure, more knowledge, and you
Yes.
respect the teaching profession. Okay. If at all tomorrow you don't get through, you would love to be a teacher. You'll continue with your PhD and whatever, you'll do that. Simple. Plus, you wanted the financial independence also,
Yes, sir.
right? A sense of financial independence coupled with your more exposure and practical aspect of law. In that sense, your own concepts will be sharpened if you're a teacher, right? That will help you in becoming a better judge, right?
Yes, sir.
Yeah, this things you can answer, not a problem.
Okay, sir.
Okay.
Hmm.
Anything else you want to discuss?
No, sir. That's all.
All the very best. You will do
Thank
good. Just don't, these are, see, final 4 days. Just chill out a bit. Don't stress too much. You're definitely going to be there. I have no second thoughts about you. Your answers are also very well opinionated, balanced, and your knowledge is also good only. I can figure that out. Though I've not asked you those questions also, but with this much discussion, you can have a idea about the personality of the candidate. Just these 4 days also keep working hard, revise
Yes,
as
sir.
much as possible. Just go through your dissertation again. What is your,
Yes.
sometimes what happens now, what is the challenge we face? Challenge is sometimes we in interview also we go by mains approach, which is that,
Mm.
so mains we first explain the concept, we'll give the background, right?
Yes.
In interview you need to be on the point. Okay, you
Yes,
have
sir.
to be to the point, no
Yes, sir.
beating around the bush. Everyone likes that
Mm.
candidate. If you'll
Mm.
give me very long answer, instead of three I'll be able to ask you only one question.
Yes, sir.
Eventually my time will also be cut, no other panelists will follow, so that can be held against you, right?
Mm-hmm.
Just try to be on the point. Okay,
Okay.
simple
Okay.
straightforward answer that is liked by everyone, and uh, to the point answers you need to give. And one more point I wanted to uh, tell you that, yeah, let's suppose I ask you about a case. Tell me a Supreme Court judgment you disagree with, right? Let's suppose this is a question. So you'll think of
Mm-hmm.
some judgment. So you can tell me in a simple word, sir, this was the ratio of the judgment. I don't agree with this judgment for the following 3 reasons, right? So don't start it by simply narrating facts. So what was happened in this case?
Mm-hmm.
This happened. Only if I ask what are the facts of the case, then say it.
Okay, sir.
So the approach is just to, in a 1 minute answer, just to show that you know things, right? You have
Yes.
a analysis part of you, which, clearly puts out everything in a concise manner.
Okay, sir.
So, like, obviously, we like shorts better than full video, right? Why?
Mm-hmm.
Simple logic, right? You
Yes.
don't want to hear each and everything. Same is with the interview also. Just put out your best point, right?
Sure. Mm.
Rest everything, you will do good. All the very
Thank you.
best.
Thank you, sir.